Welcome, everyone. This is the second to last workshop of the year because there are still classes next week. We'll meet at 7 o'clock on Monday and Wednesday for proctored exams, and then we'll meet on Saturday for a review of those proctored exams and a general send-off to success. But today we're going to focus primarily on family law and ethics, and we're going to start with my favorite place in the universe, which no, it's not the Fontainebleau Hotel pool or wherever y'all keep saying it is. It's actually the land of questionnaires. So we did family law and ethics as a class, and you guys had the distinct pleasure of learning from Marion and Rebecca, but they're on the staff and I need to see if they did their jobs well, right? So let's see. Y'all need to answer these questions, and I'm going to base how well you know the answers to how well they did at presenting, because if you don't know the answers, whose else fault could it be, right? All right, so what type of divorce state is Florida?
No fault.
No fault. All right, yeah, it's a no fault divorce state. I have yet to find a state that is an at fault divorce state. Does anyone live in a state as such?
I think they removed those in like
Yeah,
the
exactly.
80s or
But
90s.
we still mention it. It's one of those things. It's like, even though every state is no fault, I'm gonna mention this. Like it's like saying my name is Andrew and I breathe air today, right? Like, yes, we are a no fault divorce state, but we're still gonna mention it. All right. What's necessary for a court to have SMJ over divorce in Florida?
Residency
One of the
of
parties
6
needs to
months.
Residency.
Yeah, let's let Eric discuss.
I mean, I feel like everybody else kind of hit on it. One of the parties must have resided in Florida for at least 6 months, or if they have resided in 6 months for a shorter period of time, they have to be able to demonstrate their intent to permanently reside in Florida, whether it's purchasing residence, establishing bank accounts, or some other proof.
Legit. And what about establishing personal jurisdiction over divorce in Florida?
You want that to stay with me?
Sure.
Okay. Personal jurisdiction, I guess both parties have to reside in Florida, or Florida can use their long arm statute to reach a non-resident spouse that's being divorced. If the marriage existed in Florida, there's marital property in Florida, like the marital home, or some other indication that Florida can exert the long arm statute.
Nice. And the mnemonic that I use when I'm writing these essays is the JV pieced with a side of mustard, which is jurisdiction, venue, parenting plan, equidistribution, alimony, child support, esquire fees, divorce or dissolution, and then modification. And those are kind of like the key subheadings that I have in my mind when I'm kind of going through a family law essay. So this first one was, yeah, the venue. I mean, not the venue, we didn't talk about venue, but the personal jurisdiction and the subject matter jurisdiction. You'd also add venue, like where the cause of action accrued, like what gave rise to the divorce or where the defendants reside or something like that. But you want to have a jurisdiction conversation when you start a family law essay. So that's pretty cool. All right. How is marital property divided in Florida? You're off the hook, Eric, by the way.
Equitable distribution.
What does that mean, equidistribution?
There's basically a presumption that everything will be split by the middle, but there are instances where they may stray away from that.
Nice, yeah, because if it was community property, it would just be they split it 50-50. But equidistribution means, yeah, we might stray away. We're going to do things in the name of equity. And then what do you consider when it comes to equidistribution? Like, what types of property are there?
There's marital property and non-marital property. So basically, marital property is typically property that's acquired during the marriage. And then non-marital property is, for example, like if a spouse had something before the marriage was entered into.
Exactly, yeah. So you just have that discussion. Is it marital or non-marital property? Non-marital would be like things that they had before or things that they were specifically, gifted or inherited, things of that nature. Cool. All right. What factors determine alimony in Florida?
Length of the marriage, the situation of the parties.
How long? what do you know about marriages? You ever been married before? No, I'm just kidding. So you haven't even done your taxes. So how long is a short marriage versus a long marriage?
All I know is it goes like 10,
Yeah,
10 and 20 are the top and bottom, and like the middle one is like less than
there we
10,
go.
or is it less than 20, more than 10?
Yeah, in between 10 and 20 is a medium length marriage, and less than 10 is short, above 20 is a long-term marriage. It used to be 717, but they modified that a little bit, but that's good that you know that. So yeah, marriage, it endures for a long time. Before you get married, Sean, you gotta really think about it. You want to spend the next 10, 20, 30 years with that person, and that's a really important decision. All right, so what are the different types of alimony in Florida? Just in case it doesn't work out, Sean, then this is what happens.
There's the-
Pendentelite,
Yeah, okay.
Go ahead, Grace.
so pendentelite is always available. You bridge the gap, rehabilitative alimony, durational alimony, and
Yeah.
permanent alimony was abolished.
Yeah, and I know, Grace, you've been studying for this test. This is the time you're gonna overcome it. But you've seen that change happen. When you first started studying for this test, there was permanent alimony. It was 717. Now it's been abolished, permanent alimony, and it's been 1020. So, Florida's always changing for the better, for the worse, or for the hotter for sure. And that's a true change. There's no such thing anymore as permanent alimony, but you can be grandfathered into permanent alimony, right? Like if I was married to Susie and Susie left me in shambles, but I got permanent alimony, before the change occurred, then I would be able to retain my permanent alimony.
Full faith
Alright.
and credit clause would also apply to permanent alimony too, right? Like if if a court in another jurisdiction awarded permanent alimony and then, that spouse that has to pay it moves to Florida, it's still enforceable in Florida, right?
Yeah, because they'll issue what's called a final settlement agreement, and the court which issues that typically has continuing jurisdiction over, modifications or, interpretation of it. So, absent other factors, yeah, that would be the best determination, is that wherever they originally, got divorced, and whatever that court originally said will be recognized and upheld in Florida. All right, what's considered a time sharing agreement in Florida? They used to use the word custody. Honestly, family law lawyers still use the word custody. I know a lot of family law lawyers. But they're technically, I had another professor say they don't use the word custody anymore. They use the word time sharing. I guess custody sounds more like Miranda rights custody.
Yeah, you have a parenting plan, and the parenting plan will include a time sharing agreement. So it ultimately shows which parent has the child at what percentage of time. And Florida, ultimately, it's standard to have 50-50, I guess.
So I know this is ironic because last night was Valentine's Day and love was in the air, but now we're talking about divorce and such. Were you, John? I know you have a daughter. Were you married before, or you're still married?
No, never married.
Oh, never married. Okay, so you never had to do. I mean, so you and your daughter's mother don't have any of these agreements in place formally with the courts.
Yes, we do have a parenting plan. And we do have a time sharing agreement that ultimately, yeah, it's a 60-40 time sharing agreement. We have a parenting plan that says we both have equal decision-making power with regards to medical, education, et cetera, et cetera. And it lays out pretty much every single thing. Who's going to have the kid on what days of the week, if a holiday arises, how the exchanges are going to potentially take place, et cetera. And then also Florida, what is it? Sorry, I'm really tired.
You got a whole toddler.
Yeah, child support also. So you'll also end up dealing with the child support and potential deviations or staying with the Florida guidelines in that regard. All that'll be outlined in the parenting plan.
Right. And I kind of,
And arrears, if you have any arrears.
I made an assumption, and this is, there's people who are like me. I assume that because you weren't married that they wouldn't go through the courts, but of course there's still a child, that there could be a parenting planner, things like that, but there would be no alimony situation, right? Because there's no marriage.
No, just child support, no alimony.
Yeah.
but it's
interesting.
still based off the party's incomes.
For sure. So yeah, you might be my resident expert today when we do family law, but I mean, if someone like you, if you get a family law essay and they're talking about parenting plan and, you know, child support, it should be pretty easy for you to just think to your own life and be like, what factors did the court consider? Why did one of us get 60, the other get 40? And it all comes down to one thing and one thing only, which is the best interest of the child. And, you know, you'll kind of come up with that in the time sharing agreement and the parenting plan. I think there's like sole parenting, which is rare because in Florida you do have a constitutional right to be involved in the upbringing of your child. You would have to be a really bad person to get stripped. And no offense if any of you have gotten stripped, but I'm not judging you. Maybe you're just a bad parent. But like you would have to be a really bad parent to get totally stripped of your rights in Florida because of that constitutional consideration. And then there's split, like John was saying, where it could be like 50-50, or it could be like 60-40 or something like that. And then there's a type of like ultimate or parallel, which is when you split time based on, let's say, activity or area of expertise. Like Tommy will do, school, and Susie will do sports, something of that nature. So, it's all pretty common sense when we think about family law. And yeah, what's included in the parenting plan, literally just text John, he can put in the chat, like what's included in his parenting plan, literally everything. I mean, like it could come down to like, nutritional content of the food, like what extracurricular activities, how many tutors they need to hire. We love a
Yeah,
good parent.
alternately, you can leave it broad too. So, we have some terms where it's like parents will just decide on their own accord, so we'll just discuss, it's not written in the contract who's going to get what. But yeah, typically, even though we both have equal decision-making power with regard to medical, legal, stuff like that, because my daughter's mom's a nurse practitioner, I'll typically just let her heed to any medical stuff. When it comes to signing up for things or contracts or things like that, she'll always bring them to me and ask me questions, So we have a pretty amicable situation there, but I guess that's not for everybody.
You made a great point. Amicable situation, and you probably had a lawyer or you were involved that made it pretty possible to have agreements that made sense. Whereas sometimes there's, not sometimes, often when the two parties are coming up with this parenting plan, they've just gotten divorced. Tommy just caught Susie with Johnny, and like it's just not a lot of amicability going on. So a lot of times these parenting plans, yeah, they'll be like, the toothpaste must be Colgate and the toilet paper must be Charmin, like, and it's only because the mom wants to make sure that the dad or the vice versa has to do every little thing, and then the kid gets stuck in this like, they're being ruled by a parenting plan. I mean, that's the practice of law, right? So when you're writing an essay, just write about all these different factors. The more the merrier. I'm a big proponent of word count. When I'm grading essays, if like Julian or Rebecca or Marion is grading an essay, I'll look at their points, I'll read through your essay. And then one thing I always do is I just copy, paste it, and see what the word count is. And if you wrote less than 1,000 words, unless you're, Billy Shakespeare himself, like you're cooked because you didn't write enough. I recommend 2,000 words per essay if you can. So the more the merrier. You're better off writing more and talking about factors that go into the parenting plan and then go all the way up to Tommy's, dental hygienics. Okay, so what's necessary for the modification of a parenting plan?
A substantial or material change in conditions that would lead the parents to want to modify the agreement.
Right, and you'd have to petition to the court to modify. Yeah, and I like how you said a substantial, significant change. It used to be unanticipated, but they've removed that language from the statutes. So it used to be like, well, we would have never foreseen that, Tommy was gonna start playing ice hockey and then get drafted by the freaking, junior league team that required him to buy. I'm just saying that because, as a guy my age, like, me and Eric are the same age, he's got 2 kids. A lot of my friends have kids, I think about like, what do I want my kid to do that would be the least expensive? My brother played ice hockey, and I just remember like, and he played goalie. They had to buy so much equipment, you know. Like I'd be like, let's play soccer, buddy. Here's a little ball or something, you know. Hockey's an expensive sport, so you didn't foresee that you're gonna end up buying all this equipment. It doesn't matter anymore. It's just about if it's like a significant material change, then that could be. So there's more leeway now to have a modification. What is necessary to relocate a child after a divorce? This rule they amended a little bit too. I'm not even 100% clear on it. Family is not my, that's why I didn't teach it. Does anyone know the true rule about this? It used to be like a 50-mile rule.
Anything over 49 needs to get a court approval from the place of residence that's already been established.
Yeah,
You could go through county or state lines as long as it's not more than 49 miles.
I like that. The 49-mile rule. Is there any other changes to that anyone recognizes or wants to elaborate on? Something about like, even if you're gonna move them into it and then out of it, you still have to petition or something, but
The
I think if it's like
UCCJEA?
over 50, that's where you have to like actually go to the court. You have to get like the
Yeah,
consent of all the
over
parties.
50 miles.
okay,
Yeah,
yeah,
and you have to provide like all the information necessary for like contact. So like address, contact information, school information, and then like the actual justification for why you're moving the child beyond the 50-mile perimeter.
right. And at the end of the day, best interest of the child, best interest of the child, best interest of the child. We're moving the kid away so he can get to a better school. We're moving the kid away because he's getting bullied at his school, like whatever it may be. All right, what are the elements of a prenuptial agreement in Florida?
It has to be in writing.
Because
Both.
it's in confirmation of marriage, yeah.
Yeah, they have to, yeah, it has to be in writing, it has to be entered into voluntarily, and then both partners need to have independent counsel and be aware of like what they're getting into. And there has to be full disclosure of the assets and property.
Yeah, for the prenup, there's gotta be all the opportunity for counsel, fair disclosure in writing. The postnup is a little more liberal, right, in terms of like what the requirements are. Is that true? Do you know any of the elements of the postnup? And does it differ at all from the prenup?
So the main difference is it doesn't have to be in writing unless there is land because it needs to satisfy the statute of frauds. And then you're able to waive alimony in it, but it can't be temporal alimony. And then the independent counsel and the fair disclosure is the same.
Okay, nice. And I like that's an important point. You can waive alimony, but you can't waive child support, right?
Yeah.
Yeah. So that's something that people might not know. If you get married and then you have a prenup that says you waive alimony and then you get divorced, then you've actually waived alimony. But what you said is true. That temporal alimony, by that you mean like pendente lite or maybe like, bridge the gap or something. Maybe you would be still entitled to, even if you had a waiver. That'd be something you could argue for sure. How do you determine paternity in Florida?
Question on prenups, Andrew. Sorry to like linger on this, but you can waive your right to disclosures in a prenup, right? As long as you have like the ability to have review of independent counsel, you can waive any mandatory disclosures, right?
Yeah, I guess if the parties agree to say we waive the right to be disclosed of, your assets, but I think it's like presumption that, unless they have a waiver of those rights, that you do have to disclose it. What this means is like if Tommy marries Susie and Susie, thinks Tommy's a brokey, but Tommy's really super rich, he's sitting on a mega fortune and he didn't disclose it to her, and that's XYZ, like that might give rise to invalidating the prenup because of a lack of disclosure. But he's saying, what if Tommy and Susie, after review of independent counsel, said we waive the right to do disclosures? Then yeah, I believe that would be valid. Again, there's any like super family law attorneys or masters of ethics, you are all welcome to chime in today. There's a reason why I don't teach these classes. They're not my favorite cups of tea. Okay, so how do you determine paternity in Florida? Isn't it like a test?
Written acknowledgement of the father or DNA test if ordered by the court.
Yeah, and I think it has
It'd
to
be written acknowledgement of the father or the mother. Like if the father's filing for paternity, then the mother would need to written acknowledged, right?
True.
But if it's the mother that's filing, then the father would need to acknowledge.
For sure.
There's
Is it
also a
90?
rebuttable presumption that a child born in a marriage is the child of the husband. But again, that's a rebuttable presumption that can be overcome with substantial evidence.
And a child born out of wedlock, we can presume is of the mother, based on
Well,
like,
yeah, you always presume that the child is of the mother.
right. And then is it 95% the paternity test or something? Does anyone know? It's like above 95% accuracy, they're presumed. I think that's the number. Yes, all right, cool. All right. What's the legal effect of adoption in Florida? Anyone have adopted child out here? Is anyone an adopted child?
Well, the child would be able to like it's as if they were born to that person. So like they have inheritance rights. They I mean, I guess it's assuming provided notice and stuff, it severs the previous relationship with the biological ones.
Yeah, I mean, the effect of adoption is more or less they're treated as a biological child. You know, they have the same rights as a biological child. If it's a pure and proper adoption. There is one case where it's like if the previous parent dies and then they get remarried or something, and it's like a step parent adopts, then that won't sever their inheritance rights from the biological parent. But yeah, usually like if you have a baby and you're like, oh man, this wasn't for me, sorry buddy, and you put the kid up for adoption, like a formal adoption, and then the family comes in and adopts little Tommy, then little Tommy will not be able to inherit from his biological mother's estate, because the effect of an adoption is pretty much a new birth to a new family, legally speaking. Okay, and then can anyone tell me anything else about family law issues that they might expect to be tested? It's a good question. Can't get mad at me. Anything else? Family law? It's one
Child
page.
support stuff.
We said, yeah, child support. Yeah, I guess we can talk about that. We can talk about child support.
Monthly income could be imputed for child support for parents that are not employed voluntarily or underemployed.
Child support, we talk about best interest of the child. There's usually like the statutory guidelines that Marion was talking about. Obviously, you're going to consider factors like income and how much time one parent spends with a child or versus the other. So yeah, child support is definitely important. The mnemonic I use: jurisdiction, venue, parenting plan, equitable distribution, alimony, child support. The Esquire fees, I think that's because they can agree, right, that the one party will pay the other party's attorney's fees. Like that would be the only way, is if they agreed upon it. And then divorce, I guess the difference between divorce and an annulment is like, oh, it never happened, whereas a divorce is like most people get divorced. And then modification, we talked about, you need to petition, some substantial change in circumstance or something like that. And then best interest of child, best interest of child, best interest of child. If you're writing a family law essay, you don't know what to write, just write more about what would be in the best interest of the child. All right, cruising right along, and we're gonna look at essays. We're gonna look at some essays after this. Let's do ethics, business ethics. Not business ethics, just ethics. That was a movie quote. I've gotten to the point in my career where I just quote shit from stuff that nobody knows, and then I just move forward and just like only I laugh, but it's only gonna get worse over the next 30, 40, 50 years, but such is life. All right, what authorities regulate the conduct of attorney? All right, who can drop this quote from my book? By the way, people want me to record my book on Spotify. I might do that like tomorrow morning if I can wake up early enough. Do a nice little read for
I've
you.
memorized this actually. I've been like reciting this to myself.
That's fucking
Yeah.
good.
It's the Supreme Court of the state of Florida, the Florida professional rules of or the Florida rules of professional responsibility, the ideals and goals of the Florida bar, oath of admission to the Florida bar, the creed of Florida attorneys and any other documents that that are associated with the practice of law in the state of Florida.
Amazing. Yeah, Creed is always the hard one, but I always think of like, can you take me? No. Yeah, Creed. I wasn't gonna say for real. 6 feet from the edge, and I'm thinking,
You know,
hold me
Creed's
now.
making a comeback apparently with Gen Z, so they probably feel you in the
I
video
know they
here.
are because I had their song stuck in my head the other day. I'm like, why do I have this song stuck in my head? And then some kid was telling me like TikTok or something. I'm like, oh, that's why. It was about hold me now, 6 feet from the edge, and you're thinking that maybe 6 feet and so far down. All right, what is the duty of confidentiality? Does anyone know what that is? By the way, what he just recited is like I start every ethics essay off with this. I copy it, paste it if I'm writing 2 ethics essays. It's just like before I tell you anything about ethics, let me tell you where the rules of ethics come from. They come from the creed of, you know, the creed of lawyers, the oath of admissions, the Supreme Court, the professional rules of responsibility, like the all these different documents that it's just a really great paragraph that you can memorize. And I tell people like before you even start the exam, you should just be reciting this over and over in your head, and then immediately just get to typing. And then the person next to you is gonna be like, "How is this person already typing?" And it's like, "Yeah, because you know you're gonna write about ethics. It's a really great statement to start off with." And you can see Eric, you know, a week and 2 days before the test is getting there. By the day of the exam, I'm sure it's gonna be like to be or not to be, that is the question, whether it is nobler in the mind. Okay, so what is the duty of confidentiality? What do you know about this one?
It's separate and distinct from the normal attorney-client privilege rule. It's like much more broader and extends in perpetuity, where anything that you basically learn in the representation or as the attorney, anything you learn in representation of a client, you basically keep confidential and you do not disclose it. That would disclose anything that would harm your client.
What if you were representing Tommy and Tommy was telling you that all about this bank he robbed?
You keep that quiet. Assuming if he's already done the act. If he's going to say he's doing something, then no. But if you're going to be used in furtherance of a crime, you cannot keep that quiet because that would violate later down your professionalism responsibilities. But if like there was a famous case about like a murder, like that like was up in like the Northeast where like the guy had murdered someone in the past, and the attorney is required to keep that secret and not disclose it to anyone.
But like you said, if it's in furtherance of a crime, then that would be the crime fraud exception potentially. So that's a really good point. Like if your client says to you, "Hey, you know, this is how I plan on robbing the bank and killing all the people," then that potentially would not be protected by the duty of confidentiality. And what you also said is that the duty of confidentiality is broader than the ethical attorney-client privilege. Yeah, sweet. What constitutes a conflict of interest? How could we overcome? And what's an imputed conflict of interest and how can that be overcome? Conflict of interest, what does that mean? I feel like Taylor Swift had a conflict of interest at the Eagles game, Chiefs. Like she's definitely wanted to root for the Eagles when all her friends from high school were rooting for the Eagles. Her family was probably rooting for the Eagles, and her hubby was like getting locked down. She had conflict of interest, right? A conflict of interest is when your professional judgment would be compromised because of loyalties to opposing parties. I mean, there's a lot of ways we can kind of articulate that. Yeah, she's coming.
Basically, anything that would materially hamper your ability to adequately represent your client or clients is, I mean, obviously conflict of interest are broad. You have things with like, uh, prospective clients, future clients, past clients, and like, your ability to represent all those different parties. It is um, contingent on like different requirements and different disclosures, informed consent, etc. All it is for different things.
Yeah, look, it's a Florida bar essay. If it smells like a conflict of interest, you want to write about why it may or may not be a conflict of interest. Like, don't just be like, oh, that's irrelevant. Like, they didn't tell you, like, oh, Tommy used to work for the Florida Panthers and now they're suing the Florida Panthers for no reason. Like, they told you that even if he only worked as, and they're like, well, he was only a janitor and he cleaned up the rats after they had a hat trick. Like, you guys understand sports? How's it going? But like he only cleaned up the rats after the hat tricks. He was just a janitor. He had nothing to do with like their upper level, management. It would be like, well, maybe, you know, it's still a conflict of interest and you would still need written disclosure from both parties. Like that's what you'd always kind of come down to. Like it's in the best interest to get written disclosure and you know, written consent from both parties because there could be an air of impropriety. So yeah, written consent is
And
usually
even if you get the consent from both parties, because I think one of the things that was it Rebecca said that in her PowerPoint that like if you as the attorney think that even if both parties are like the past client and the former client think it's okay, but like you think I don't think I can adequately do this because of the material harm that could befall you, you can decide to say no.
Yeah, for sure. So imputed conflict of interest, how could that be overcome? Imputed means like, I mean, you guys all remember this thing. I know it seems like a long time ago. But remember the COVID-19 virus? The what's it called? COVID-19, whatever it's called. That was imputed to other people, right? If Tommy got it, then Johnny got it, and then Johnny got it, then Susie got it. Next thing you know, people are singing on their balconies from France. Like that's what imputed means. It's like one attorney has a conflict of interest that can be imputed to the other attorneys in the firm. But how can that be overcome?
Screening that attorney off, making sure that they're not involved in any way with the council, but they also are unable to share in any of the profits that are received by the firm for representation.
Exactly.
If you do that, you don't have to obtain informed consent from the former client. You just have to provide reasonable information to them of the situation.
Excellent. And you know, for me, it's just like conflict of interest, imputation, screening. It's like three buzzwords. Buzzwords are how, you know, people are like, oh, Andrew, how'd you get a 78 on the essay? I just use a lot of buzzwords, you know? That's it. Just like use the words, use the lingo of the people. You know, if you go to Cali, be like, what's up, brah? If you go to Miami, be like, literally, bro. Like just speak the way that people speak and the way that they speak on the I have a friend, she's going to trial this week and she is subbing in. She's what's it called? What's it called when you sub in law? Like substitute counsel or something or coverage. She's coverage counsel. She's coverage counsel and she has to read this thing and she's reading it to me to see if she's good at it, right? Reading is a skill. And they use this word contumacious, right? That it was deliberate and contumacious. And I had to Google that because it sounds like a hilarious word. Does anyone know what that word means? Contumacious? Right? I had to look this word up. I was like, this lady, contumacious. It means in archaic law, stubborn and willfully disobedient to authority. His refusal to make child support payments was contumacious, right? So like that's the type of language you want to use on the bar exam. Be like, this contumacious and deliberate behavior would be why, you know, and they even lit it for child support, right? Anywho, I'm just saying, use the lingo. Don't use the word contumacious when you're, you know, trying to pick up a girl at the club. Use contumacious when you're writing, when you're in front of the judge, right? On this essay, use imputed, conflict of interest, screaming. These are good words. Speaking of good words, what is the duty of decorum? What is the duty of decorum? I wonder how Google defines decorum. Behavior in keeping with good taste and propriety. I was gonna say not acting a fool, right? Like, you know. But I like theirs better, right? Behavior in keeping with good taste and propriety. I think of decorum usually as like your duty inside the courtroom. Like, remember the one guy who like tackled the judge? He speared the judge, or the one person.
Yes.
Yeah, the one person who starts singing a song, like, you know, crying and singing songs, like, you know, it's not really proper decorum. Decorum would be like wearing a suit and tie and kind of like, yes, sir, yes, your honor, you know, like that's proper decorum. I think of candor kind of like, I think of decorum and candor kind of like inside and outside the courtroom. Decorum is more like acting properly inside the courtroom, and then candor is more like, you know, treating co-counsel with respect and politeness and things of that nature. Let's see what Google finds candor as.
I thought candor was more like honesty.
Yeah, that's what I mean. Honesty, expression, frankness, like grace, being honest with you, truth, decorum. So yeah, just being like respectful and truthful, right? Decorum and candor. I mean, they'll be easy to see if the guy's lying out of his woo-ha and he's screaming aloud in the court or whatever, and he's, you know, calling him a Coco Banana Head, then like this could implicate these duties, candor and decorum. It's just better words to use than you know, he's not acting properly as an attorney. He's violating his duty of decorum and his duty of candor, right? Better words to use. Okay.
Andrew, do you think that we would earn points if we say like those duties of candor and the decorum extend also to like court staff and even jury members, you know?
Yeah, you could get extra points. I mean, if the facts implicate that, and even if they don't, you know, it can't hurt. But yeah, you know, they're saying John's saying that there's some lying going on in the practice of law. I think it's interesting ethics, teaching lawyers ethics. You know, the irony is deep because I know a lot of lawyers. I know where their moral compasses lie. But that's neither here nor there. Okay, so what's the duty not to commingle? Does anyone know what that means?
Do not mix,
Yeah,
Yeah, client funds and your funds have to be separate. You put your client funds in like a specific like client fund trust account or whatever secured account, and you don't put like your other personal funds in there and commingle them.
exactly. The duty to separate earmark funds. I mean, maybe you could have like an account, like you can use your money to cover like court fees or something like that, like administrative fees, but you can't just be like mixing money, client funds versus operating funds versus personal funds. Yeah, things like this. All right, when can a lawyer be paid by a third party for his or her services? Anytime, right? Pretty much. I mean, not anytime. It's just like if the third party pays, you are still you still have your obligations to the client, even though, you know, mommy's paying, you know, I'm representing Susie here. I have had to tell this to my students as a bar prep tutor, like, yo, even though, you know, you're paying me, mommy, I'm working with Susie and like, I'm not gonna like, you know, me and Susie will do our sessions. We'll send mommy to check, you know, it's kind of the same way in the practice of law. Like your interests are to the client, not to the third party, like whether to settle or not. There is one third party that can uh, have involvement in that decision to settle. Does anyone know who that is?
Insurance companies.
Yeah, insurance companies. Because the thought is like you wouldn't even be involved in this action if it wasn't for the insurance company. So they're more than just like a mommy in that situation. They're more like a daddy. Okay, so the attorney may accept third-party payment if he can maintain his independent judgment and not be influenced by the payment of third party. He retains the duty of loyalty and confidentiality of his client, and the client gives informed consent. Okay, so that's a nice piece about third-party payment. The attorney may accept third-party payment if he can maintain his independent judgment and not be influenced by payment of third party. He retains the duty of loyalty and confidentiality with his client, and the client gives informed consent. We like that. Yeah, and insurance is good. I got a lot of life insurance, you know, worth more dead than alive. All right, so when may attorney's fees be awarded in Florida and what rules apply?
by law, by rule, and as a punishment, like sanctions.
Yeah, or maybe by contract, right?
Oh, right, by contract
Yeah,
too.
yeah, by law, by rule, by contract, by sanction. I like that. Grace, you've been studying. I see you.
The
You guys
thing is that it doesn't translate into the essays. That's the problem.
Yeah, for sure. That's the problem. We're gonna try and overcome that. We're gonna try and screen that from being imputed to the test. We're gonna try and screen your problems on writing practice exams from being imputed onto the actual exam. We want your knowledge to bleed through on the exam. Just keep writing more, you know, doubt yourself less, you know your stuff, the more words, the better. You got this, you're passing, Grace. All right, so what are the requirements for referral fees in Florida? Anyone know? Referral fees?
Proportional to what the respective attorney's work is.
The
I
best way to
guess.
The best way for referral fees is like they're not allowed, they're disallowed, unless, you know,
Oh,
like
okay.
that's the way to look
Yeah,
at
okay.
it. Unless, you know, they participate in it, they get informed consent, and I mean, in reality, yeah, everyone does referral fees. I'm in a networking group where it's a bunch of attorneys just passing, you know, cases to each other and getting referral fees. Like they definitely do that, but they all participate in the, you know, especially on the bar exam, you know, be a very ethical lawyer. If you're going to get a referral fee for a matter, then you should really be hands-on in the matter. What are the requirements for contingency fees in Florida?
They have to be
33 and
reasonable.
1/3 if it settles pre-suit, 40% if it goes to court.
Right. And when can you not get contingency fees?
Criminal and family cases.
Right. And h- how does the client know what's the contingency? Does he just find out at the end, or does he have to have any way of?
Statement of client's rights.
Mm-hmm. So they'll.
There's
the cli-
also a contingency agreement, so you'll have that and the statement of client's rights. Usually they'll get both.
Can you explain what the contingency fee agreement and the statement of client's rights are?
Well, the contingency fee agreement is in essence going to be the retainer. So that's going to be the attorney-client contract. The statement of client rights is going to outline their rights within that contract, as well as their rights to, exit from that contract with no repercussions within 3 days' time of entering into it or receiving that statement, whichever comes later.
Right, and it pretty much includes, I mean, these agreements include the calculation, like how it's going to be calculated. And then at the end, when it is dispersed, they get a final calculation to make sure that like it was calculated as it was supposed to be calculated. And then can you explain that you said the 3340 rule?
Yeah, so Florida bar limits the contingency fees you can accept. And if you settle a case pre-suit, it's limited to 33 and 1/3 or 33.3333, whatever you want to write it as. And if you have to take it to court, then you can take up to 40% contingency.
Nice. And I mean, contingency fees are found often in personal injury, for sure. Like,
Yeah,
you know.
and it changes. I forget if it's over $1 million, it lessens. But off the top of my head, I can't remember without looking at notes.
So, I have a personal injury attorney in my business group. You guys actually probably know him if you listen to the radio. His name is David San Pedro. He's from Panther in San Pedro. They do a lot of advertising here in Miami on the radio. He's a really cool guy. He has an office down in Miami, and he did his presentation, and he talked about something that I never even thought about as a personal injury attorney. But maybe, John, you can attest to this. He said that in Florida, for a survivorship claim, it can only be brought by a spouse or a minor child. So if someone or a wrongful death claim too. So if someone dies and the person trying to bring the claim isn't a spouse or a minor child, then they have no claim to bring, which really makes it difficult in Florida for those types of claims to prevail. They need to be a spouse or a minor child. Does anyone have any experience with that? Maybe
Well,
not.
yeah, a survivorship claim that can only be brought by the estate, right? I thought of the deceased person.
Yeah, so maybe it's wrongful death I was talking about, not survival. That a wrongful death claim can only be brought by a surviving spouse or a minor child. So wrongful death, yeah, that's what it was, wrongful death, right?
Isn't that what was
Yeah,
brought after
that'd be the
OJ was
surviving
found not
claim.
guilty? There was a wrongful death claim, right? In like the civil context against him. Wasn't that what happened?
Yeah, that must have been brought by that woman's uh spouse or a minor child, I would say. According to this dude, David San Pedro. Anyway, I'm not here to teach, personal injury, but that's what he was teaching all of us. And I thought that was interesting. But anyway,
Hey,
Lynn?
Andrew, I just wanted to add, there was a case here in Tampa where a girl, a daughter, her father was in the hospital and was pretty much the same thing. And she tried to bring suit and she couldn't. And they were looking to change the law or to make some update. But right now, you can, that's correct.
Yeah, it's wrongful death, and she couldn't bring the claim because she wasn't a minor child.
Right.
Yeah,
Yeah.
that's what this dude David San Pedro was saying. Let's see what he's up to, David San Pedro, and then we'll get into the real lecture. Yeah, look at him. Big dog, David San Pedro. All right. So yeah, you guys can email him about that. Okay. What are the requirements for contingencies in Florida? What are the rules regarding attorney advertising and solicitation in Florida? Can you I mean, you can't just be like, we've won 100% of our cases if you only had 2 cases. That'd be like me saying 100% of my students pass and I only had one student, right? Like you can't be like misleading or false. What about accident victims? What about ambulance chasing? Are you allowed to do that? What's the rule in Florida about, soliciting someone who's been involved in an accident?
Can't do it till after 30 days of
30 days.
that.
Right. So I'm telling you, if you're ever in Florida and you get in an accident, the police are involved, insurance company involved, on that day, after 30 days, you're gonna start getting a lot of solicitations. And then what do they have to put on those advertisements or solicitations?
Name
By
of the attorney
mail,
and address. And then
Yeah.
it's an advertisement in red ink particularly.
Right. They have to make it really clear that like this is a legal advertisement. And then one thing that I didn't see, it says what else can you include on this essays? There's a duty that I think is important to mention, the duty of competency, right? Like you can't just take on litigation. Like just because you guys pass the bar doesn't mean you can go and represent, complex matter, right? So you're saying you can solicit to past clients and family, right? But you can't solicit to people you don't have a relationship with or that aren't in your family. That's true about solicitation. Anything else about the business transaction rule? What does that mean, Grace?
that the lawyer cannot like make a business with a client, like he may he cannot engage in business with a client for his benefit without making a full disclosure.
Right.
I don't remember the rule exactly, but yeah.
No, I hear you. And then also like it's not that easy for a lawyer to receive part of a judgment unless there's, these disclosure and agreements and things of that nature. So yeah, it's all good stuff that we can look out for. Okay, so just in general, we see ethics, I mean, really duty of confidentiality, decorum, duty of candor, duty not to commingle, duty of competency, and then it's usually about fees, like referral fees, attorney fees, and then something about advertising and solicitation, and just, kind of be prepared to write that part out. And I love how someone put it in the chat because the more times you hear it, the more likely it is that you're going to be able to remember it. But the ethical rules of Florida lawyers are outlined in the decisions of the Florida Supreme Court, the Florida rules of professional responsibility, the ideals and goals of professionalism, the oath of admission to the Florida bar, the creed 6 feet under of the Florida bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. Discipline may include admonishment, suspension, or disbarment. I mean, you can get 6 points. You can get more points than Maria got on her essay. If you just write that, you could get 6 points and you could get a really good start to your essay. All right, let's see. Before we jump into some essays, anything going on in this chat? I gave you all some really great Florida multiple choice tests. County where one spouse resides, forum is a circuit court, best interest of the child, presumption is 50-50 in the child's best interest, and you don't have to file the plan when you both agree on something. Since July 1st, 2023, Florida law deems a parent's relocation within 50 miles as a substantial change in circumstance for modifying the time sharing scheduling parenting plan. Yeah, that is the change I saw. So material change or substantial change in income over 50 miles, 15% or $50 in income per month is substantial. So yeah, I mean, there's some people in here who have some of these agreements in place that are really the people to ask. If you're confused, just text message them or DM them. Yes, but not for post-nuptial, they must disclose assets. So the Good Dad Bill of 2023 allows unwed fathers to gain legal parental rights and support obligations without the need to go to court to establish paternity. All right, I honestly am not too familiar with the Good Dad Bill, but it's cutely named. So which is the same as federal. So the grounds for annulment include duress, incapacity, bigamy, and consanguinity.
Yeah, consanguinity is basically like you're too close in blood relation.
You already knew I was going for that one. The fact of being descended from the same ancestor. Oh, okay, incest. Yikes-a-roni.
Consanguinity is a little nicer way to say that.
Yeah. Okay. All right. So if y'all learned anything today, you learned a different than consanguinity and such. All right. So the ethical duties of Florida lawyers are outlined in the decisions of the Florida Supreme Court, the Florida rules of professional responsibility, the ideals and goals of professionalism, the oath of admission to the Florida bar, the creed of the Florida bar, and other documents. All Florida lawyers must comply with the professional responsibilities, obligations, or subject to discipline for noncompliance. Discipline may include admonishment, suspension, or disbarment. Eric's got this mnemonic for y'all. Let's hear what we got. Some crazy, really ignorant gents obtaining counsel. Okay, cool. I play golf every year in this tournament called the Gents Club or Gentlemen's Club, something like that. I haven't played golf since then. Supreme Court rules, ideals, and goals, oath, and creed. Supreme Court rules, ideals, goals, oath, and creed. All right, we like that. Yeah, Taylor Swift is definitely commingling. Screening to overcome conflicts, truthfulness, settlement agreements, lawyers lie. Yeah, men lie, women lie, lawyers lie more than all. Don't mix money, client funds versus operating funds versus personal funds, for show. The attorney may accept third-party payment if he can maintain his independent judgment and not be influenced by the payment of third party. He retains the duties of loyalty and confidentiality with his client, and he gives the client informed consent for sure. Yes, with 3 eyes. Do you know what you call a fish with no eyes? A fish. Is it true to say the guidelines are between 50 to 40%? Yeah, I think that those are the guidelines. I mean, you can look back at Marion's lecture. I don't know too much about the guidelines, to be honest, but I know that there are statutory guidelines. Class actions, for sure. You love insurance. You legitimately love them. So, oh, he's in personal injury. Okay. Survivorship is brought by the state. Wrongful death is brought by the surviving family. Yeah. So I was, I was misquoting my man David San Pedro, where a survivorship claim can be brought by the estate. That's fine. Whoever's the estate can bring it. It's the wrongful death claim that for personal injury needs to be brought by the surviving wife or the minor child, which makes it kind of difficult for wrongful death claims in Florida. Yeah, the main difference between survivorship claim and wrongful death claim. Survivorship claim are claims that existed that the state is now bringing after the party is deceased, where wrongful death claims is actually like the civil equivalent to like murder or manslaughter. It's like saying like we're suing the doctor for malpractice that led to the death. So it's suing for the civil claim that led to the death versus lingering claims that the estate could bring on behalf of the decedent. All right, thanks. Type of recovery. Can solicit the past and clients and family for sure. Business transaction rule. Okay, Susan has to leave for an appointment. Keep up the great work. Key rules about business transaction rules for attorney. The primary concern is that a lawyer's personal financial interest could clash with their duty to act solely in the client's best interest during a business transaction. All right, sweet, amazing. So overall, just in general, I think family law, ethics, super manageable subjects, right? Subjects that we could do well in. And if we see them, you just kind of dig into common sense, right? Like what happened when your aunt got divorced? What happened? What should a really ethical lawyer do? And if you just do those things and just, when in doubt, write it out, you'll be fine. So today we're going to do our, let's call it ethics, family law plus workshop. And I'm going to move at a pretty brisk pace today because I'm trying to show y'all what to do down the wire. Like the things we did 3 months ago are not things that we should be doing today, right? You got to really be focused on your time, right? Right now, I'm like, all right, we have 30 minutes. Knowing me, I'll take a little bit extra, but we have about 30 minutes. How can I be most valuable to y'all and to myself if I was taking this test? Obviously, starting from the Florida essays themselves. And because the family law ones are kind of like, the laws have changed a little bit, let's jump right into this February 2023 essay. First and foremost, we're going to ask ourselves, why are people texting me right now? What's the call of the question? Draft a memo that addresses the following. So whenever they give us the actual things, I mean, these are my headings, right? Like literally, these are my headings. So, right? I haven't even read the essay and I'm already typing and the people next to me are mad. They're like, how come this guy's typing so fast? What does he know that I don't? I know how to pass these essays. Leave me alone. So I'm going to go to, bar examiners. Give them a little kiss on top. No, don't do that. From examinee, right? Humble yourself. You're just an examinee regarding, I don't know, grandma, right? Daughter, son, father, dispute. I don't know, that's a fair way of doing it. And then I like to do this right at the beginning because it allows me to use the letters forevermore. And I'm a time-saving master. Like, you know, time is always of the essence when you're taking an exam like this, especially if you're not a fast typer, you're a slow reader, you're someone who likes to think, you know what I mean? There's a lot of reasons why time is of the essence. If time is not of the essence when you're taking this test, I don't think you're taking the right test, right? And unless you have a full extension, even if you have a time and a half extension, I still would be moving briskly because you don't have time to not be able to write things down. So 2 from re, and then date 2/15/25. Okay. This memo will discuss. Well, I'll just keep it 1, whether grandma's likely to succeed, blah, 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 blah. 2, the impact of any on la di da di da. And 3, any ethical considerations that may be received. Okay, boom. I already set it up just like that. So now part 1 is grandma and adopting daughter, grandma adopting D and S. And whether grandma is qualified to adopt, and whether mother, father, and father's parents must receive notice or consent to the adoptions. Grandma adopting S, and I just want to know, like, there's little things that we're supposed to answer. Is G qualified to adopt? Must M, F, and F's parents receive notice or consent? And 3 is the impact of any an adoption would have on father's child support or rearage and his obligation to pay child support and any ethical obligation. So there's actually like 4 things. Okay. So 1 is grandma adopting the S. Is grandma whatever, is she able to adopt and must they receive notice? The second thing is the impact, and the third thing is the ethical consideration. Sorry about that. So the second thing is the impact of adoption on F's child support, arrearage, and obligation to pay child support. And then the last thing is ethical considerations raised by G's boyfriend's offer to pay her legal fees. All right, this is a horrible family law essay. This is about as hard as it gets. I remember when this one came out, people were like, you know, the adoption thing, I was so freaked out about it. My one student, Gabby, was like, I'm so happy that Andrew taught me about adoption. Like, I don't even remember teaching me that, but whatever. It was a tough essay, right? It was a really tough essay. So all we can do is our best, but because of the nature of time today, we don't even have to do our best. We just need to learn from it. Because at this point, I'm not so concerned with how well y'all could do on these essays, unless it's a practice essay. But when it comes to just studying, I'm more concerned of like, what can we learn from these essays? So let's learn from this essay. So we're thinking about, can grandma adopt? What's going to be the impact on father's child support? And what are the ethical considerations by grandma's boyfriend's offer to pay? All right, let's take a look at that question. So daughter and son are half siblings who are mother's children. Daughter is 11 years old and son is 18 years old. Son's father is deceased. Daughter's father is named on daughter's birth certificate, but never married mother. Okay, so we see some issues here that they're half siblings. Daughter's 11, son's 18, so the son's actually a major. Well, a major. And then the son's father is deceased. And then the daughter's father is named on the daughter's birth certificate, but never married mother. So mother's got 2 kids, half siblings. One kid's dad is dead, and the other kid's dad is named on the birth certificate, but never married mother. All right. Grandma is mother's mother and is a widow. Daughter and son have resided at grandma's house throughout their lives. So we're already thinking, what rights does grandma have? Under the Florida Constitution, she is going to have some rights. During that time, grandma has sufficient income to meet the children's needs. Grandma remains in good physical health and can continue to provide for son and daughter financially. Mother occasionally lives at grandma's house, but has left daughter and son with grandma during long stays with friends, stints in jail, and a trip to a rehabilitation center. All right, so mother got some problems, right? She's in jail, she's going to rehab, she got 2 baby daddies. One baby daddy probably got shot in gang violence, and the other baby daddy, I mean, he doesn't seem to be a scholar, but maybe I'm making assumptions. So mother finally has told grandma that she agrees to grandma's request to adopt daughter and son who are both in favor of the adoption. All right, so the best interest of the child, the kids want to go with grandma, mom's on drugs, grandma at least is making cookies in the house. It seems to be the best situation for the kids. Father did not assist mother financially during the pregnancy with the daughter. I told you this guy's a deadbeat. Father has been incarcerated, I told you, since daughter was 2 years old, and father is not anticipated to be released for another 3 years. All right, so this guy's literally in jail. Grandma doubts that he would agree to her adopting daughter, as grandma has a contentious relationship with father. I mean, I don't blame you, grandma. This guy's been in jail the entire life of your grandchild. I mean, maybe he was innocent, but he probably wasn't. Father was ordered to pay child support after daughter's birth, but made payments sporadically, right? Deadbeat. Even though he was employed full-time, deadbeat, before his incarceration had the ability to pay, deadbeat. He is currently in arrears, deadbeat, and has never tried to communicate with daughter while in prison, super deadbeat, right? Father's parents buy daughter birthday and holiday gifts, but rarely spend time with her. All right, now father's parents, they didn't do a good job raising their deadbeat kid, but at least they're giving the grandbaby some gifts. So like father's parents aren't the worst people. Like, there's the dead baby daddy. We don't know too much about him, but he didn't seem like he was there, but maybe it was natural causes. Then there's the other baby daddy who's a total deadbeat. Then there's the mom who's a total drug addict. Then there's the mom's mom who seems to be pretty nice making cookies. And then there's the dad's parents who seem to be like at least sending gifts, but they rarely spend time with her. So grandma is the best, father's parents are the second best, and then it's just a descending order of like terrible peopleness. Grandma is not aware of their expressing an interest in adopting daughter and is unsure. Grandma's not aware of their interest in adopting daughters, unsure whether they would consent to adopting daughters. So grandma, she's not sure what the other grandparents would think. Grandma would like your law firm to represent her in connection with adopting daughter and son. As a gift to her, grandma's boyfriend, okay, grandma, sexy grandma, maybe bringing up the fertile octogenarian rule, has offered to pay her legal fees. Okay, so, a lot of family law issues, a lot of ethical issues. I'm telling y'all, this is the hardest family law essay I've ever seen. I'm really happy that we're doing it together because I didn't even really want to do too much family law today. But if we're going to do one family law essay, let's do a tough one and let's try and glean some rules of law. So can grandma succeed? Is Broski going to have to pay his child support? And could sexy grandma's boyfriend pay the legal fees? No way to find out but to jump into the model answer, right? See how they did it just like me. Wow. 2 from bar taker attorney. I would write examine me, but whatever. From grandma's adoption impacts ethical considerations, right? They did the exact same as me. We're all cool here. All right. Adoption is a termination of parental rights in the current legal parents and the giving of those rights to another parent or parents over the adopted individual. So what am I going to do? Mister, I'm having a workshop today. I'm going to take out these rules of law, right? And I like doing bullet point because, bullets. Okay. In the state of Florida, anyone may adopt another. This includes the right of a married couple, same-sex couples, and an individual adult to purely adopt another. Individuals interested in adopting another must file a petition with the court first for termination of parental rights described below, then for petition of adoption. When a petition for adoption is submitted for minor children, courts will consider various factors to ensure that the adoption is in the best interest of the child. Such factors can include the adoptive parent's fitness to take on the role and responsibility of a legal parent, including sufficiency of income, mental, physical, and emotional health, and more. If a court wishes, it may also prescribe a 6-month trial period during which the child may live with the possible adult, after which the court can determine suitability of the arrangement based on the prior 6 months. Courts will also give priority of adoption to blood relatives. This is a great paragraph about qualifications to adopt, right? Qualifications to adopt, anyone can adopt another. We're going to look at all these different factors and we're going to give priority to blood relatives. Here, grandma's qualified to adopt daughter because she's making cookies. It's not relevant that she's a widow because we're not hating on single people. Similarly, daughter and son have lived in grandma's house throughout the years. She's also demonstrated she makes cookies. She's going to the gym, she's working on her fitness. Similarly, a court will not require the 6-month waiting period since daughter and son have lived with grandma throughout their lives. Further, grandma's a blood relative, so grandma's getting the kid, right? We like that. Grandma should get the kids clearly in this situation. Either we have the kids raised in a prison, we have the kids raised by a drug addict, or grandma. Like, what are we gonna do else? All right, qualification to be adopted. Similarly, any individual may be adopted in Florida, including adults. The court will seek consent to the adoption for children who are 12 years or older. The court may ignore the failure to consent if the adoption is in the best interest of the child. Further, an adult wishing to be adopted is currently married, but the adult and the spouse must give consent. So they keep harping in on this that you can adopt an adult. I don't really understand why you would ever adopt an adult, but like,
There was a show about adopting adults. It was very creepy.
I feel like that's right up your alley of shows that you watch, Grace. In a loving way. You just like to watch a lot of shows, I know. What's the show coming out tomorrow? White Lotus? Oh,
I
can't
have
get-
no idea.
All right, good. Me neither. All right, here both daughter and son are eligible to be adopted. The fact that son is 18 years old and an adult does not disqualify him from being legally adopted by grandma. The facts do not indicate that he's married, so only his consent is required. He has agreed to the adoption. Similarly, a daughter is only 11 years old, does not require consent. The courts will consider it positively and that she agrees. Therefore, daughter and son are eligible to be adopted by grandma. And that was the easiest part. Like, if you read this essay and determined that like grandma was not qualified to adopt and that the kids would be better off with the drug addict or the prison dad, then like you should not go into family law. All right, let's see the next question. Consent to terminate parental rights. So mother voluntary termination. Legal parents must consent to the voluntary termination of the parental rights. Specifically, they will be given notice of the petition to terminate the parental rights with a summons to appear in court. Upon summons, the parent must appear in court to relinquish their parental rights. Consent must be given in good faith and not under duress or undue influence. Undue influence may be met if there is a person of authority exercising control over someone in a way that an unreasonable person may not agree to. All right, really solid stuff about voluntary termination of parental rights. So here, I mean, this was about notice and consent. So let's pop this right here. Cool. Here, mother appears to have consent to the termination of parental rights when she said she finally told grandma that she agrees. However, the facts seem to indicate that there might be undue influence, as she said finally, which indicates that grandma has been asking for a long time. The facts do not indicate that grandma is exercising any control over daughter, convince her to agree. Further, mother appears to have drug problems. What do you mean appears? She's definitely evidenced by her multiple stints in jail and her trips to rehab. Yeah, she definitely has drug problems. Therefore, so long as the court does not determine that mother's been unduly influenced by grandma, then her consent to voluntary termination will be accepted. All right, peace. A father may be deemed to have relinquished his parental. So we're talking about involuntary termination abandonment. A father may be deemed to have relinquished his parental rights in certain circumstances, such as if he's abandoned his children. Abandonment has occurred if a parent has never provided any provisions for their children, despite being able to, nor attempted to have any positive relationship with their children. When a parent has abandoned his child, he is not required to receive notice or give consent to the termination of his parental rights. However, legal parents in jail who have not abandoned their children must be given notice of the petition to terminate their legal rights and opportunity to consent or object. If a parent objects to termination of their legal rights, a court may nonetheless judicially order the termination, involuntary termination, if it's in the best interest of the child, best interest of the child, and if other conditions have been met. I mean, again, like this was a really hard family law essay. People freaked out about this essay, but if you just kind of like, hold steady in the heat of battle, you could have done fine on this essay and been like, yeah, the deadbeat the deadbeat dad in jail probably is not going to be able to stop sweet grandma from getting the kids, right? Here it does not appear that father has completely abandoned the daughter because he did pay sporadically. They do not indicate the last time he has paid child support, and if it was that many years ago, then sporadic payments may not be sufficient to prevent him from having been considered to abandon his child because he paid less than he was owed, even though he was able. And he never tried to communicate with her. Even if they determine that he has not abandoned the daughter, the court may determine to judicially order the termination of his rights based on the fact they never tried to have a relationship with the daughter, does not keep up with child support payments, is a total piece of shit, and is incarcerated since the daughter was 2. Therefore, father's rights, even if he does not consent, may be terminated either way by abandonment or judicial order of involuntary termination. Okay, how about parents' rights? individuals must have standing in order to be able to consent to termination of parental rights. To have standing, the individuals must be a party to the suit. Similarly, grandparents will only receive notice of the adoption petition in certain circumstances, such as when the child has lived with the grandparents for a 6-month period within the last 24 months. Like whoever wrote this model essay clearly was a family law attorney or worked in like a family law office or something. But that's why we learn from these. We don't have to write essays that are as amazing as these, but we would have to write these. So I don't know if this is going to be on the no, this is still going up here. Okay. So yeah, like this was a really good piece that like, you know, grandma doesn't always get notice, but if the child's been living with grandma for the last 6 months, for a 6th period within the last 24 months, so 6th period of the last 24 months, then grandma does get notice. Here, father's parents are not qualified to receive notice of petition of adoption because they've not lived with them at any time. Similarly, they do not have standing to contest the adoption because they're not part of the suit. So yeah, deadbeats parents, you know, they sent little gifts in the mail, but they don't have standing. Therefore, even though they provide birthday gifts and holiday gifts for daughter over the years, the father's parents will not be given notice or standing to contest the daughter's adoption. All right, impact the adoption would have on child support arrears and obligation to pay. Child support is a legal right owed to the child that cannot be waived in any premarital agreements or otherwise. A parent owes this funding to the child according to the agreement set forth by the court, and failure to pay child support is punishable by law. Subsequent adoption of a child does not impact the amount previously due by the parent. However, the future obligation to pay may be terminated by the new parenting arrangement. All right, so yeah, like you're in arrears, buddy. You're still gonna have to pay him. Best case scenario is you get out of jail and get slapped with a huge child support payment bill, which you don't pay, and then you go back to jail because you try to rob them, whatever. Here, father will continue to owe the prior child support due to his daughter. However, his future obligation to pay will cease when he relinquishes his parental rights to his daughter, either voluntary or involuntary. All right, so that was the family law part. Again, if you were like, what was that? I would never have been able to write that essay. Just remember, neither was anyone else who took this exam, but anyone who has, you know, experience in life could sit down and be like, all right, the deadbeat dad who never talks to daughter probably isn't going to get what he wants. Grandma cooking cookies and, you know, singing lullabies probably is going to take over. Like that's kind of the general approach to this. But we did tease out a lot of really good laws about adoption that you could use on a family law test. Now let's see how they wrote about ethics. I would have originally started with my statement about where the laws come from, and then I would take this statement, which I think it seems like Grace, you know, already told us. An attorney generally may not accept payment by third parties unless certain conditions are met. The attorney may accept third-party payment if he can maintain his independent judgment and not be influenced by the payment of the third party. He retains the duties of loyalty and confidentiality with his client, and the client gives informed consent. A third-party payer should have no privilege or opportunity to influence the case in any way. Here, grandma's attorney may accept boyfriend's offer to pay grandma's legal fees so long as grandma gives informed consent, and attorney ensures that boyfriend does not influence the case, and that attorney upholds his duties and loyalty of confidentiality with grandma. See, loyalty, confidentiality. There are no facts present to indicate that boyfriend plans to interfere, so this will likely be an acceptable arrangement. You see, some of these essays, a lot of these essays, the ethical, you know, discussion is very short. And that's, you know, fine. You don't have to go crazy on ethics. Like when I say go crazy on ethics, meaning it doesn't have to be, you know, the main part of your essay, but I would err on the side of writing more than writing less. So I would give them a nice, you know, a nice 10 to 12 minute, pour my heart out on ethics before I spend, you know, the rest of the essay elsewhere. But like, you know, just if you do run out of time and you're cruising through essays very quickly, like it's okay. Anything you do on test day is okay. Just move forward, do your best, and you know, you can save yourself. If you do bad on one essay, do great on another essay. If you do bad on essays, do great on multiple choice. Like it's not over until it's over, and that's a really good approach. All right, so we're gonna do some kind of speed essay drills right now. I think that was pretty fine for like family law and ethics. I mean, the main family law things are definitely gonna come up and be the main family law things, but I want to focus a little bit, you know, on different types of essays that we could potentially see, especially mixed ones. Like this one that's real property in Florida con law and ethics seems pretty nice to me. Whether you've done this one before, it's not really important. Let's just kind of learn from it. So discuss the issues raised by the owner's rights in the various portions of north, south, east properties as addressed above. Also discuss any ethical issues involved with owner's attorney's role in preparing and delivering the requested easements to west owner for execution. Do not discuss any issues pertaining to the easement of the west property. So first and foremost, I want to make sure that we document this is FEB24, question number 3. And this one, the family law one was like the most recent family law one. Okay, July 2023. Question 1. July 2023, question 1. All right. This one I'm not gonna like, tease out for you about how I would arrange it, but if you had to guess, how do you think that I would arrange this memo? Exactly as I arrange every freaking memo. 2 free rum date. This memo will discuss exactly what y'all told me to discuss, and then lock and load. I'm about to hit you with everything under the sun before I move to my next essay. Like, it's very mechanical. Very mechanical. Okay, so let's read this essay. Owner has owned, let's not make sure he's not a buyer owner, right? Owner has owned certain property, Blackacre, for 30 years. Owner now plans to redevelop Blackacre, and she's encountered 4 issues involving Blackacre's property line. All right, Blackacre, let's see what's going on. First, owner has recently discovered an issue with the southern boundary of Blackacre in revenue survey. When owner purchased Blackacre, it was described in her recorded deed as Lot 1 of a certain platted subdivision. Several years later, the current owners, southern owners, of the property located to the south of Blackacre, southern property, acquired the southern property pursuant to a recorded deed reading Lot 2 of the same subdivision. 10 years ago, southern owners constructed a fence along the boundary lines between lots 1 and 2, shown in old surveys, although southern owners apparently knew the fence was constructed inward of the property line. A new survey recently revealed that the previous surveys were incorrect. The new survey correctly showed that a narrow strip of land running along Blackacre's southern portion but located outside of southern owner's fence, southern strip, is actually located within Lot 2 rather than Lot 1. Since purchasing Blackacre, owner has mistakenly but in good faith believed that the southern strip was located within Blackacre's southern boundary until the new survey revealed the error. Owner never enclosed the southern strip, but at all times used, improved, and maintained the southern strip in a normal manner as part of her backyard. Second, the property located to the north of Blackacre, north property, includes a private roadway that is adjacent to Blackacre's northern boundary, North Road, which owner has used regularly since purchasing Blackacre to gain access to the northern portion of Blackacre. The owner of the north property, north owner, recently built a fence and gate on north property's southern boundary, thereby restricting owner's ability to use North Road to access Blackacre via its north entrance. However, an alternate route to the east remains available to owner to access Blackacre. Prior to this time, owner used the North Road across the northern property without any objection and with no express permission from north owner. All right, holy bananas. Third, owner acquired an additional strip of land from vacant property located to the east of Blackacre, east property titled solely in the name of John Smith, a married man, to accommodate her intended development. Accordingly, owner recently reached an agreement with John Smith on the sale of the strip, east strip, and the respective parties then closed on its conveyance to owner, evidenced by a deed of the east strip duly executed by Mr. Smith. Fourth, owner needs an easement over the property located to the west of Blackacre, west property. When owner contacted the west property's owner, west owner agreed to grant the easement, but informed owner that he did not want to incur the expense of hiring an attorney, and thus requested that owner direct her attorney to draft the easement and send it to west owner for her signature. Discuss the issues raised and owner's rights to the various portions of north, south, and east properties addressed above. Also discuss any ethical issues involved with owner's attorney's role in preparing and delivering the requested easement to west owner for execution. Do not discuss any issues pertaining to the easement in the west property. If they say don't discuss something, my recommendation is you don't discuss it, right? Other than that, there's a lot to discuss in this essay. This essay, I'm sure if you took the February 2014 exam, you would not be pleased, right? It doesn't seem like an easy essay. But this is the exercise. And when I took the 2017 exam, I had 2 notebooks, old-fashioned notebooks. I usually have a little one on my desk, but I had 2 notebooks, and one was my MBE notebook, one was my Florida notebook, and I did it all by hand. If I did an MBE question and got it wrong, I would write down in my little notebook, a deed in lieu of foreclosure will not eliminate junior mortgages. And then for my essay notebook, I did exactly what I'm doing right now. I just went through all the essays and then I read the model answers and then I took out the rules of law, not like the facts about Tommy, Johnny, and Susie, but the rules of law. And just like I'm doing right now, I copied and pasted them. But instead of doing what I'm doing right now on computer, I did it by hand and I wrote down every single one. So by the end of the, my studies, I had 2 notebooks, one with a whole bunch of cram guide points. And if you're in my MBE class, you've seen I've turned those cram guides into documents that you all have to read by yourselves, right? And in for the essays, we do it every year. When we do these workshops, I just tease the rules out and I put them on a document and then you review them. But like there is something very true about when you have to slow down and write things, you learn it more than this. Like just copying and pasting here isn't, as effective as like, shit, my wrist is hurting because I've been writing these things down, but now you remember it. So, if you're really struggling to learn how to articulate these rules of law, that's the bullheaded approach that I took myself in 2017 and it worked, which is, I had to learn this shit too from the ground up. And sure as shit didn't teach me in law school. I had to, write it all out by hand. And then there's something really tied to handwriting and memory. And that worked for me. I'm trying to streamline this for you where it's just like, you're teasing out the rules of law. But ultimately, when it comes to preparing for the Florida essay, this is the surefire approach. Go through the previous essays, tease out all the rules of law, familiarize yourself with them, and be able to articulate them. And then on test day, just dump them all out and apply the facts. And you should do more than passing. All right, let's see what rules of law we got from this one. This question raises the issue of adverse possession regarding lot 2, the southern property, easement by necessity and by prescription regarding the north property, the validity of the conveyance of the east strip, and the ethics of preparing the deed for an unrepresented party. Let's get it. In order to prevail for a claim of adverse possession, the adverse claimant must prove that her use was open, notorious, hostile and under a claim of right, continuous for the statutory period, and exclusive under the common law. The period of time for common law is 20 years. Yes, that's true for common laws. Like that's not true in Florida. In Florida, adverse possession is 7 years. Prescriptive easement is 20 years. Common law adverse possession is 20 years. This mother trucker didn't even know, like I did that. This mother trucker didn't even know what the time period was in Florida. So they gave the common law one. Still got the model answer. That's the point. You don't need to know every single detail to pass this test, but the more details you know, the more likely you are to pass the test. Okay, so this is important about with color of title and without color of title. I don't know how they're going to explain it, but I'll explain it myself real quick, see if we're aligned. With color of title means you have like a defective deed. You have some document that purports title, but you don't actually have title. If that's the case, you just need to have some enclosure or some, fence around the property or something. Without color of title means you don't even have a document purporting title. All you have is your squatter's rights. Then it's necessary to show that you've paid the taxes. So let's see if they agree with that. An adverse claimant may also claim adverse possession pursuant to statute under color of title or without color of title. To prove under color of title, the adverse claimant must record the deed with the county clerk, which reports the vest title and the adverse claimant. To prevail on a claim without color of title, the adverse claimant must make a return with a tax assessor, exactly what I said, and pay the tax on the property claimed. All right, we see eye to eye. Both under color of title and without color of title require the claimant to be in possession for 7 years. Never mind, I'm not trying to hate on this person. This person knew their shit, right? They knew that adverse possession was 7 years in Florida. They knew that with color of title, you are supposed to just, file the deed and have an enclosure on a property or something. Without color of title, you actually need to have paid the taxes, which is an additional step. So that's a really cool point that we can take about this. I mean, I'm sure it's a detail that you guys might not even understand, but just understand adverse possession. I use the mnemonic ocean, right? Open, continuous, exclusive, adverse, notorious, and then for the statutory period. 7 years in Florida. So Ocean 7. It's a good mnemonic. Okay. In this case, while owner was in exclusive possession of the property as evidenced by her cultivation, her possession was not hostile. She was under the mistaken belief that the property was hers, and she was not claiming the property under the interest of the southern owner. While her possession was also open and notorious, that is visible to the southern owners, and continuous for the period of time that she cultivated, she is not satisfied the element of hostility. The facts do provide the time period she was in possession, but that is not a necessary piece of information since she did not satisfy one element. She would not prevail in her claim for adverse possession under common law standard. Owner has not satisfied the requirements to claim adverse possession under statute. She did not record a deed purporting to vest title to her, nor did she make a return and pay the taxes. Owner has not satisfied the requirements for adverse possession and therefore will not be vested with title to the strip between 1 and 2. So what they're talking about here are interesting points. For adverse possession and for like, easement by prescription, there's statutory requirements and then there's the common law requirements. So like that's kind of what they're explaining. They're like, either way, you couldn't do it. It's like there's a statutory prescriptive easement in Florida that's like about, farmland and, being able to access a road, but like that's not the only type of prescriptive easement. That's just that's not the only type of statute of easement by prescription. That's not the only type of public necessity easement, but that is a statutory public necessity easement if it's like a farm trying to connect to the road or something. So just because these essays talk about the statutory requirement and the common law requirement, they're pretty much talking about the same thing, which is adverse possession or easement by prescription or easement by necessity, whatever it may be. Okay, so owner may claim that she has a prescriptive easement or an easement by necessity over the northern property. Wow. In order to prove by an easement by necessity, owner will have to prove that she has no other access to a public road and must cross the northern property. Owner may sue the northern owner and may be entitled to compensation. Once the compensation is paid, the easement is established. So in order to prove by easement by necessity, they just need to show that their land is hemmed in. It's no access to a public road, right? In this instance, owner has an alternate route, therefore there's no easement by necessity. Even if she had an easement by necessity, the easement ends once the necessity ends. Under the common law, an easement by necessity may exist over one property if the land was previously in common ownership and subdivided. If the subdivision leaves one property landlocked, the other will have an easement for ingress and egress, right? So that's a common property that's subdivided, and now there's no, the one property is landlocked. Like those are all good words, like hemmed in, landlocked, no access to a public road. These are all terms of art that's, are associated with easement by necessity. In this instance, lot 1 did not come out of common ownership with northern property. Further, there's no necessity because she has an alternate route. Owner will not prevail on a claim for easement by necessity. Owner must prove that her use of the road was open, notorious, and continuous for 20 years in order to establish easement by prescription. She must also prove as hostile and adverse to the northern owner's interest. So easement by prescription is 20 years. I'm actually glad because there's a few Florida essays, model answers, where they get these years wrong and they still publish them because the FEBE has, I guess, no time on their hands to edit these essays. But this one is proper. 7 years for adverse possession in Florida, 20 years for prescriptive easement in Florida. For prescriptive easement in Florida. 7 years for adverse possession, 20 years for prescriptive easement in Florida. In this instance, her use appears to be hostile and adverse to the northern owner since she was without permission. Further, it appears that the use was open, notorious, as she did not object. If the reason why he did not object is due to lack of knowledge or use, she may not have satisfied the element of open, notorious use unless the owner knew or had reason to know of her use. The establishment of a right to an easement by prescription depends on whether the owner knew or had reason to know of her use and the use of statutory period of 20 years. So just something else I'll put in this essay to keep in mind is the difference. Well, a key difference between adverse possession and prescriptive easement is the element of exclusivity. What I mean by that is like multiple people could have the same, prescriptive easement. Like we're all walking across this bridge, but adverse possession, it's like if you and another person, you're going to possess as co-tenants. Like you guys are, it's got to be exclusive to you or to your co-tenant. It's not something that like multiple people all have to.
Hey, Andrew, obviously this is Florida, but I actually have a quick question. So for adverse possession, if two people are residing in the same residence and they're trying to claim adverse possession, if all the elements otherwise were successful, can they get it? And if so, it's like what tenants in common? Is that what happens basically?
Yeah, there'd be tenants in common in that situation. I mean, there's two situations. There's a situation where Tommy's squatting for 7 years and then he pieces out and Johnny takes over, that would be tacking, where you could reach the statutory requirement because you've tacked on the second adverse possessor tacks on from the first adverse possessor. But if Tommy and Johnny are friends, lovers, or whatever, and they take the property together, then yes, they will take the property as tenants in common. So then after they have acquired title, and one of them, conveys the property or whatever it may be, it would be in consideration of them having acquired as tenants in common. It's not like one party leaves and then the other party, takes over. They did acquire as tenants in common in that fact pattern. Okay. In this instance, her use was not that hostile. 20 periods were good. All right, let's look at the East. Right? I'm from the East. I was born in Miami, raised in Philly, East Coast boy. The question raises the issue of the validity of the conveyance for John Smith to the owner. The recital of a married man raises the issue whether a spouse has any rights in the property that should have been conveyed at the time of the conveyance to the owner. If the property is owned by a person solely, it may still be subject to the rights of the spouse if it's homestead property. The homestead property is which the owner resides as primary residence. In this instance, the property is vacant and therefore could not be the primary residence of John Smith and his wife. The spouse therefore has no rights that need to be conveyed. The conveyance from John Smith to the owner is valid. So this one was about, they said it was Florida con law. This is all it was that it potentially brought up homestead, and then it didn't because it wasn't even a primary residence. And they still called it a Florida con law essay instead of a property essay just because of the homestead exemption. So I want y'all to really understand that the homestead exemption is like rears its little head everywhere. All right, the conveyance of the deed, which was prepared by an attorney for owner and sent to the owner of the West, raised the issue of how an attorney may act towards an unrepresented party. This is good stuff. An attorney may indicate to the unrepresented party that's disinterested. That is, the attorney must disclose to the unrepresented party that he is acting in the best interest of the client and not the interest of the other party. Further, an attorney may not represent the interests of two clients whose interests conflict unless the attorney believes he can fairly represent both and both clients consent in writing. In this interest, the West owner asked the attorney to prepare the deed and send it to him. The deed should be sent only with the express understanding that the attorney represents owner only and that the West owner is not his client. Attorney should also suggest that the owner would consult an attorney before signing the deed. I mean, again, this was a monstrous essay, but it was really just like easement by prescription, easement by necessity, adverse possession, and then like unrepresented or represented party for the ethics. It was like more bark than bite, I would say. But I'm sure, like, look, we barely took any facts here. It was not that much. It was just like, being able to write this essay and apply the facts. This one was literally 2 pages, one of the shortest essays I've ever seen. But still a model answer. All right. In the nature of being, I forget the word that I'm supposed to use. Contemptuous or something? What is it? Contumacious.
Contumacious.
Yeah, and it had been contumacious. Let's do one more. Let's just real quickly pick an essay that looks hard, that looks fun, and just kind of seeing what we can learn from it. But this will be even quicker, even more fun. Yeah, I think contracts and torts. Right, this one is about Rodney, and he's got this like looks like a what's it called? Non-compete agreement, something like that. Who knows? At this point, I'm like, shit, the test is coming up in 3 days. I got to get through these essays. I got to learn. So what do? I jump right into the model answer. To, from, date, re. Okay, that's how I'm going to write my essay because all the model answers are like that. Andrew suggests writing it like that. I'm not going to be stubborn and bullheaded and hard-headed. I'm just going to do what everyone else does. I'm going to write to, from, date, re, and I'm going to get to business. All right, claim 1, breach of contract. So this is February 2020, the last one for the day. I got a student in between this class and my UB class. Rachel and Alexis have no pity for me. So this is Feb 2020, I said? Feb 2020. And just in case I forget to do this, put this in the chat right now. I'll put this in the classroom. Trying to put everything in the classroom. If you need access to any resources or anything, just get in touch with us. We want everyone to have everything they need to pass this test. At this point, it's all about test passing. All right, you guys have access to that. I said it was February 2020. February 2020. All right, this was right before the COVID. Yeah, this was literally right before COVID-19 because it happened in like March when Rudy Gobert was coughing on the microphone. That was early March. So yeah, this was right before the COVID bar. Okay, cool. So Feb 2020. Let's see what we got. So breach of contract claim, whatever. Employment is considered at will unless there's generally employment is considered at will unless there's an enforcement employment contract. A contract is an agreement formed following an offer, acceptance of the offer, and consideration. Right? Again, I'm not really concerned with the facts of Rodney. You know, Rodney seems like a cool dude, but I'm just worried about the rules of law. Are they testing rules of law that I don't know? And if they are, I need to learn them. So as consideration, he said he'd work, whatever, whatever. All right, the statute of frauds. The statute of frauds requires that certain contracts must be in writing and signed by the party to be charged to be enforceable. This agreement includes contracts that cannot be completed in 1 year. The statute of frauds applies to this agreement because the contracts, whatever, whatever. See, this is, you know, you got to manage your time. That's why I really need people to do practice essays, practice essays, practice essays. Me, as you may or may have not noticed, I'm a speed demon, whether it's, you know, on the football field, the basketball court, or when I'm teaching a class. Like speed has always been an asset of mine. So when I'm writing essays, I'm able to write more than the person next to me because I'm a fast person. Whereas if you're someone who's been like, you know, Franklin the Turtle their whole life and you write a little bit slower. I don't know if any of y'all know Franklin the Turtle. That's a super throwback. But if you're Franklin the Turtle and you write a lot slower, then you have to write like this person wrote. Like they wrote, the statute of frauds requires certain contracts be in writing and signed by the party to be charged. This includes agreements that can be complete with 1 year. I would have literally given them the entire My Legs mnemonic, and I would have given them the entire swap mnemonic, and I would have done it all so quickly. Like, watch how I'm going to do it. Contracts that contemplate marriage cannot be completed within 1 year. Contracts for land, executorships, goods over $500, and suretyships. Exceptions include that's not what I wrote. Specially manufactured goods, written confirmatory memos, admissions in court, promissory estoppel, and partial performance. Right, all right, that took me a minute and a half, but whatever. It was points I could have got that maybe they didn't get because they weren't like super relevant. But to me, that's a detour, not a frolic. Like I'm okay to get that point in, and maybe I didn't get points, but oh shit. Whenever I do My Legs, I immediately do. Whenever I do statute of frauds, I immediately do My Legs and swap because I just feel like I don't want to leave any meat on the bone, right? Sorry for the vegetarians out there. Okay, so Ronnie breached this shit for show. Although Becky will likely want to require that they compete the terms of the contract, the court will not reward specific performance and contract for services. So that's just a key point. This is because specific performance for services is difficult to enforce and may be considered involuntary servitude, which is unconstitutional. So service contracts, we're not going to have specific performance. We're going to have, legal monetary relief. That makes a lot of sense to me. Okay. However, even when the services are unique or to be performed by a person with unique skills or talents, the courts will not award specific performance for the reason above. I mean, that's not always true, but yeah, actually that is true. That is true. Like they're not gonna award specific performance because you can't get Michael Jackson to sing, but you can say that a duty is non-delegable if they are unique. So that's kind of what I was thinking. All right. Generally, a non-breaching party to an enforceable contract is entitled to compensatory damages. Where possible, a non-breaching party can recover expectation damages, which are intended to put the non-breaching party in the position where she would have been had the contract been performed, right? I always write the same thing about contract damages, right? They said, you know, non-breaching party, compensatory, there could be expectation. For me, it's going to be legal versus equitable, right? And then legal is going to equal compensatory Compensatory versus punitive. Punitives are rare, so we're gonna go with compensatory. Compensatory is gonna equal expectation, incidental, consequential, lost wages, lost profits, nominal damages, restitution, reliance, cost of cover, mitigation costs, things like that. And then equitable relief is gonna be like specific performance, injunctions, TROs, rescission, reformation, promissory estoppel, if you kind of consider in that way, quasi contract. In some ways, replevin, if it's like a secure transaction type contract. Anywho, look at all that stuff I just wrote down in a minute and a half. I'm a little more thorough than the guy next to me, but it doesn't matter. You don't have to be that thorough. You just have to find your balance and write 3 strong essays. And the more tools you have in your toolbox, the more likely you are to pass. But you don't need to use the same tools that everyone uses to pass. You just gotta use the tools that you have and provide a great answer. Okay, so here, there's incidental damages, which include those costs incurred that were reasonably foreseeable and ameliorating the breach by locating a new radio personality. I mean, I kind of think that, to be honest, they conflated incidental with consequential. I think incidental are to recover for the breach, and consequential are those that were foreseeable in light of a breach, but like, whatever, a little conflation is not the worst thing. So they said,
Wait, can you read that the consequential are the ones that are foreseeable and the
yeah, I
incident
mean, in
was what?
general, you associate the word foreseeable with consequential damages, and incidental damages you should kind of perceive with, I mean, you should kind of equate with ameliorating the breach. Incidental is to ameliorate the breach. Consequential are damages that were foreseeable in light of a breach. Like you knew that I was gonna use the money to buy the car and boomity boom, like that's consequential. So that word foreseeable, like this isn't a wrong definition. I'm just saying usually it's nice to equate that word foreseeable with consequential damages. Incidental is more like ameliorating the breach. I like that. There are no incidental damages we know about, but there could be. They could also receive consequential damages. All right, let's see how they did this. Consequential damages. All right, so they did use foreseeable twice. All right, fair enough. Consequential damages are those damages that arise in the breach that were reasonably foreseeable at the time of the contract that the breaching party should have known were reasonably foreseeable as a rather breach, including business losses. All right, at least they use the word foreseeable twice here, meaning that like they agree with me. Like foreseeable definitely needs to come with consequential damages. It's not wrong to come with incidental damages, but it's like consequential damages and foreseeability go together like lamb and tuna fish. I meant peanut butter and jelly. I'm sorry. Okay, so W law can show that one of these things happened. They'll be able to recover additional consequential damages, lost profits, right? It's weaker because they've already been in negotiations, partial motivation, some consequential damages, lost profits, all good stuff. Here, the non-compete clause. So non-compete clauses are getting weaned out in federal practice, but I still think this applies in Florida. The court will closely scrutinize the non-compete and will enforce the clause only if the non-compete clause protects legitimate business interests, is no more restrictive than necessary to protect that interest, and sufficiently limits in scope and duration. Absent a showing of unique circumstances, courts will not enforce non-compete clauses for more than 2 years. In Florida, there's a presumption that non-compete clauses for a duration of less than 6 months are reasonable, and the non-compete clauses of more than 3 years are not enforceable. Right, so non-competes need to be reasonable in 3 factors: geographic scope, subject matter, and duration. So geographic scope, subject matter, and duration. Okay. Here you got legitimate interest, Rodney's popping, but it's too long, too short. That's what she said. Intentional interference with a business relationship. Okay. W law may also have a claim against WWF for intentional interference with a business relationship. This is a major tort. Remember, there's a contract torts essay. Torts, there's negligence, duty, breach, causation, damages. We're going down that whole alleyway. Then there's the intentional torts. And I always tell people assault, battery, trespass of land, trespass of shadows, conversion. But then there's the ones that start with the I, intentional infliction of emotional distress, intentional interference with a business relationship, also known as tortious interference. Then like intentional endangerment, malicious prosecution, elements of privacy torts, elements of defamation of a public person in terms of malice. But yeah, intentional interference or tortious interference. I've seen this tort tested a lot, including the most recent exam. So make sure you understand tortious interference, intentional interference with a business relationship. A claim for that tort requires an existing contract. The defendant knew or had sufficient knowledge to know with reasonable certainty that the contract existed, and intentional interference with the contract that causes the other party to breach. So that's intentional interference with the business relationship, also known as tortious interference. Honestly, as a business owner, if I were to ever sue someone, it would be for this mother trucker right here. People be interfering all the time. I'm just from a different world where I just let bygones be bygones. Okay, so Rodney told WF that he had non-compete, whatever. We're gonna talk about this, but tortious interference. So this would include losses. So there may be a claim here for tortious interference that they knew there was a contract and they interfere with it. Be on the lookout. Another one to be on the lookout for, and it's kind of ironic that these are the ones because this was tested the last time too, I think. Same thing, tortious interference and defamation. They came together. I think that of the torts, defamation and well, obviously negligence, like and with negligence, it's usually responding superior, employee liability, things like that, third party liability. But they really love to test premise liability, products liability, and defamation. Those three are tested a lot from my experience. Products liability, premise liability, and defamation. Premise liability, like trespasser versus like invitee, licensee type shit. Defamation, like public versus private plaintiff, and then the media defendant rule, 10-day retraction, things like that. Slander per se, crimes of moral turpitude, loathsome disease, unchastity or about a person's business, those kinds of considerations. And then products liability, like design defect, manufacturing defect, failure to warn or inadequate warning, implied warranties of merchantability, implied warranty of fitness for a particular purpose, and then theories of negligence in products liability. But that brings us to defamation. Defamation is an actual tort which arises when the defendant makes a defamatory statement concerning the plaintiff and there's publication of that statement. A defamatory statement is a statement of fact that either on its face negatively reflects on the plaintiff or the statement would lead a reasonable person to infer a negative defamatory fact about the plaintiff. Opinions are not actionable as a defamatory statement. Good, because if they were, man, I would be in jail. I guess not in jail, but I have a lot of opinions, no defamation. But yeah, if you want to ask me, I'm not really pleased with the Drake album. I feel like if someone would have called me something like what he called Drake in front of 134 million people, I would have addressed it in my next work of art. But to each their own. Peace be to Journey. So yeah, we're talking about drunk driving. It's considered negative to his reputation. Rodney thus made a defamatory statement. Truth is a complete defense of defamation. That's a good thing, right? Like, Drake is saying that, oh, Kendrick defamed him by calling him a pedophile. Well, Drake, if you really been doing, if the business is true, fam, then that's not defamation. And another argument that Kendrick can make is like, bro, this was a song, like we're just singing, it's art. But again, I'm not on the legal team. I would say that it's not the coolest thing ever to sue another person when you're supposed to be a rap star, but whatever. At least he makes good music for the ladies. So, however, Rodney's statement that Jack drives drunk every weekend is much broader than saying he has a single 5-year-old conviction for drunk driving. Further, Jack has stopped drunk driving, so there's no defamatory statement because is he a drunk? Is it truthful or is it defamation? I don't know. Rodney published a statement by communicating it to others. All right, here we go. As a general rule, damages need not be shown to make a prima facie case for libel, defamation published in a permanent form. Damages must be proven for slander, spoken publication of a defamation statement, unless the slander is actionable per se because it meets one of the definitions. So here's their piece on slander per se. I gave you the mnemonic club. That's where y'all find me. Slander that negatively reflects on plaintiff's business or employment slander per se. Here, the tweet was electronically published in permanent form on the Twitter platform. Thus, this is liable and no damage need to be proven to have a cause of action. I mean, I'm not sure I 100% agree with this essay writer's discussion about libel. I mean, from my understanding, there's slander per se and there's libel per se, and they're both crimes of moral turpitude, loathsome disease, unchastity, and about a person's business reputation. So that's a good mnemonic. Crimes of moral turpitude. I know we're doing a lot of definitions. What does that even mean? Turpitude. Depravity, wickedness. Yeah, that could be someone's rap name. Moral turpitude. Loathsome disease. That could be someone's rap name too, if you wanna go with that route. Crimes of moral turpitude, loathsome disease, unchastity. Chastity. That means like you're a promiscuous girl, and then business relationships. Or promiscuous boy. Whatever you're waiting for. Okay, so slander per se, we got that little statement. Did I get that statement down in our thing? Yeah, slander per se, crimes of moral turpitude, loathsome disease, unchastity, or business relationships. Beautiful. Generally, falsity of a statement and fault, some degree of culpable negligence or intent, need only be proven if the defamatory statement concerns a matter of public concern, right? So we said actual malice for a public plaintiff, negligence for a private plaintiff. So actual malice for public plaintiff. And then see what else? Here it could be argued that Jack is a public figure. Again, this is how you write good essays. Here it could be argued that Andrew, as the world's greatest tutor with, all this amazing partnerships with all these famous people, he's a public figure. Alternatively, bro, you're not a public figure. This is negligence, XYZ, boomity boom. Like, you could just make these arguments for anyone, any person they present to me. I don't care if they're a tutor, if they're a chef, if they're running for political office. You should make the argument of whether or not they're a public figure. Unless they tell you it's Jay-Z or Beyonce, then, it's up for debate, and we're going to have that conversation in real time in front of the essay reader. He can do this by presenting evidence supporting the fact. Since he is a public figure, he's going to have to show malice. Okay. Assuming Jack can show fault, he can recover for both economic damage such as lost profits. Generally, non-economic damages are not awarded for defamation since the harm sought to protect is economic. Okay. That's a good point we can make. Generally, you're not going to have non-economic damages for defamation. But you could definitely have some sort of like I'd say injunction or, stop order to stop saying these things. And then finally, remember I said intentional torts. Everyone remembers assault, battery, trespass of land, trespass of shadows, and conversion. But do you remember the ones that start with intentional? Intentional interference with business relationship, and here intentional infliction of emotional distress. As a matter of course, whenever I write a torts essay, I bring NIED, IID, because it's always like it can be argued, There's some things that you should just kind of always bring. On a torts essay, I like to tell the reader, Florida has abolished joint several liability for negligence cases, that Florida is a modified comparative fault state, and in Florida, punitive damages are limited to 3 times compensatory or $500,000, the greater of the two. There's just certain things that I'm just on the lookout for. On torts essays, yeah, NIED and IID, they just kind of come along for the ride because they're pretty easy to argue. When you're writing these torts essays, imagine you're a personal injury attorney like John Bates in the room. A is going to argue for assault. Alternatively, A is going to argue for battery. Alternatively, A is going to argue for IID. Alternatively, I'm going to argue anything, judge, to get some money here because this is my job, right? Like, the more arguments you can make, the better it'll be, right? The more chance of success. All right, finally, IID requires extreme and outrageous conduct, exceeds all bounds of decency in society, knowledge or reasonable expectation that the conduct will result in emotional distress to the plaintiff, and plaintiff must actually experience emotional distress. It is unlikely Rodney's tweet, which is mere words on a platform where people express their views, opinions, and argue frequently, be considered extreme and outrageous. All right, whatever. We're not really worried about this. We're just talking about what is IID. IID is a really good tort to bring in if possible, and we'll put it on our outline. So you see what I just did today, and literally an hour and a half at most, because we spent a half hour bullshitting. I took 3 essays, and the one I did pretty thoroughly. And I outline them. And how did I outline them? I just took the rules of law, I copied them and pasted them, and now I'll read them over, literally when I'm going to the bathroom. I don't want to say that, but like literally when I'm eating dinner, when I'm in the Uber, like anytime, I'm just reading these things over and over again so that I can articulate them on test day. This along with, of course, the questionnaires. And you could see we put the questionnaires right here at the top. You should go over the questionnaires all day, every day. I'm literally just gonna add this material as workshop, family law and ethics plus. Put the link, add it, and then I could make it February 25 workshops. Boom. All right. So this was a really great workshop. We did, a half hour extra, but that's because I like to eat when I'm cooking. And, I'm not the type of person that's going to skimp out or likes to bail out at the end. If you ever see me, I got hella medals over here from running, 5Ks or whatever. My last, stretch is faster than any other stretch. I like to finish strong, and I think a lot of people fall just short on the bar exam because they're doing good, and then their anxiety starts to get the best of them, and then instead of locking in and finishing strong, they kind of fall off and leave some points on the table. So, try to eat what I'm cooking here, which is be diligent, be disciplined, do your absolute best, and finish strong. And I think you'll have a lot of success. So this week we're going to do a proctored exam Monday at 7, 2 essays. They'll all be graded. All the family law essays, every essay that's submitted will be graded with time to review. Don't worry. And then on Wednesday, we have a brand new 100-question multiple choice test that honestly should take you probably about 2 hours, but we'll give you 3. We'll give you 4.5 if you have an extension. And then next Saturday, a week from today, we'll do a review where I'll talk about the essays. I'll go over some of the multiple choice questions, and then hopefully I'll go over some questionnaires and some final things to just send you off. The February Florida bar, I said this from the beginning, it's a lot because there's so many subjects to cover. There's Christmas, there's New Year's, there's, things that got in our way. So we really do teach until the final moment. And this was the last substantive workshop. From here on out, you've learned every subject, you've seen it all as it's presented, but I would encourage you to go back, contracts, torts, con law, real property, family law, all the multiple choice subjects that we did, the procedures, the evidence, wills, trusts, commercial paper, secure transactions. But as you're studying, remember, turn your weaknesses into strengths, make your strengths stronger, and prioritize based on likelihood of being tested. Don't consider what's likely to be tested based on what your Aunt Susie said on Reddit. Base what's likelihood to be tested on cold, hard facts. Criminal procedure, civil procedure, definitely going to be tested. Ethics, definitely going to be tested. And then the big ticket ones like con law, torts, contracts, property, wills, business entities, right? Kind of in this order. And then family law, trust, commercial paper, secure transactions. That's kind of the order of priority in my mind. So I'm going to go ahead and stop this recording, but I'll address any questions in the chat for sure.